Welcome back to the PI show. We're discussing the role of a barrister. Martin, what about this?
Yeah, have a look at what we've got on the screen here. Here's two fellows dressed up in their traditional, I emphasise traditional barrister
It's the first time I've
outfit.
ever worn, ties and wigs and gowns, and bloody hot too.
Yeah, I was lucky enough, privileged enough to recently appear in the full court of the Supreme Court to admit another practitioner as an Australian practitioner, as I described before. As a requirement of that, you have to wear the appropriate gown and the appropriate
The only
dress.
countries in the world where they still wear that stuff is
I think so.
Australia and England.
In England, that's correct.
Why?
Certainly don't do it in the States. Look, some of the judges relax the need sometime. I was up at Mildura one day when it was 45 degrees. The judge, obviously, in practical terms, says it wasn't necessary to dress up in the full regalia that day. But look, it's
It
tradition.
surely intimidates a lot of people. I mean, I know a lot of clients, as soon as they see the judges and the lawyers dressed up in a garb, they really feel intimidated.
Correct. Look, it's a tradition. It's being discussed. The attorneys mentioned it a few times, but the tradition continues.
Right, we better get on with this role of the
Yeah,
barrister.
the role of the
Martin.
barrister.
Tell us what the main principles are.
As I said before the break, the first concept was the duty to the court, the second one was the duty to the client, and the third the duty to the public. A barrister must not engage in conduct which is dishonest or otherwise discreditable to a barrister.
Well, that speaks for itself.
It does, is prejudicial to the administration of justice and is likely to diminish the public confidence in the legal profession or in the administration of justice, or otherwise bring the legal profession into dispute.
What happened in that case of Punch and the New South Wales Bar Association?
Well, excuse the pun, viewers, but of course Mr Punch was knocked out. Mr Punch was a barrister in New South Wales who appeared for an armed robber. He, however, didn't tell us the truth. What he did, the client had told him that he was involved in the armed robbery.
Can I tell you what he did?
Yeah, please tell me, Tony.
He made an alibi for his own client.
Yep. His own client, he found 5 alibi witnesses. Unfortunately for Mr Punch, this was taped and the tape went to the legal profession. What happened then was the legal profession brought him before a tribunal. The tribunal said his behaviour was obviously...
Outrageous.
Thank you.
Outrageous.
And they knocked him out.
That's a fellow that believes in winning at all costs,
Yep.
no matter what the state plays.
Yeah. And the other important part about this is he was properly dealt with, taken before the profession and removed from the role.
And his prospects of being a lawyer again, Marty?
I would
Zilch.
say no prospect at all.
Okay. What about, one of the biggest questions I'm asked all the time is, how do you select a jury in a personal injury case?
On a personal injury case, as we've discussed previously, viewers, the judge is there to administer the law and to tell the people what the law is. The jury are there to decide the facts. In a personal injury claim, they usually have a group of people brought in 12, and then they find 6 jurors to sit and listen to the case.
Don't they normally get a group of people from the roll?
Yes.
And they have them at the back of the court.
Yes.
Their names are called out. They call out the 12 names, and then they go to the respective parties, and they have them strike out 3 names each. Is that correct?
That's correct, because you have the right to be judged by your peers. You might not prefer one of the jurors, so you leave one of those
But
people.
who does the striking out? Do you leave it to the barrister, or you as the instructing solicitor assist in that role?
Absolutely assist in that role.
Why?
Because your opinion may be persuasive for the barrister to say, I object to that one.
So why would you strike out the pleasant person at the back of a court with a tie on, suit and everything else when you're representing an injured party?
Look, the person may have had an office job in IT, and what we're discussing in a case might be an injured worker that gets injured in a factory floor type accident. That person in IT may not be suitable to understand all the issues involved. On the other hand, it can be exactly the reversal of that. Somebody who is a worker who hasn't got the training in some areas, as I said, a factory worker, dealing with another issue where somebody got hurt in an office.
And what about colour, Marty? You know, occasionally you're acting for South African clients or people from that background, and does that play a part?
Difficult topic to discuss, discriminatory issues. I would have thought, yes, those issues have to be properly discussed between the barrister and the solicitor, and whether an objection takes place, it's up to them.
And you can't tell me that prejudice doesn't kick in when you're doing these cases.
I think there's some prejudice for various types of people, yes.
So anyway, look, let's move on. What about suing a barrister? Can you sue a barrister that's presenting a case because he or she are doing a lousy job, in your eyes?
There's again a distinction. A barrister gives opinions, a barrister gives advice, but when a barrister is on his feet at court and he says various things and plays various tactical moves, they are immune in Australia from being sued for what happens in the court case.
You say Australia, what about the rest of the world?
Well, in a number of other countries, being England, USA, Canada, USA, Canada, European Union, Singapore and India, they can be sued, I should say.
Didn't the High Court in Australia say the reason why you can't sue a barrister is because you'd have to run the case twice, wouldn't you?
You'd have to run it more than twice when you think that their first duty is the duty to the court.
Well, that's true too. Yeah. I mean, and every time you run it, you'd come out differently, wouldn't
Well,
it?
it may come out with a different decision, that's right.
What about in these criminal trials where you've got hung juries and you go back again? I mean, the parties improve their case, don't they? Generally, the prosecution does a better job the second time around, don't they?
It can, but remember, in a criminal case, it's a different test altogether. In a criminal case, you are innocent until proven guilty.
Well, can I ask you this? What do you reckon's harder, being a solicitor or a barrister?
Look, they each have their nuances, they each have their challenges. For a barrister to be up on his feet, thinking on his feet, to be addressing a jury, to be coming up with quick questions and quick answers, that's difficult. That's, fantastic advocacy occurs in the courts. However, a solicitor that's back in the office taking the calls, doing the paperwork, getting everything ready and prepared, that's also got its trials.
But surely the barrister's on his feet presenting a case doesn't mean that he's doing the right thing. The instructing solicitor should be on his mettle too, shouldn't he?
Yes, the instructing solicitor is there at court to assist the barrister, and if there are any issues, he can always pass the note across to the barrister if the barrister may have overlooked something. They work together in the presentation of the case, and it's not hard for a barrister to say to a judge and to a jury, "Can I have a moment, please? This may be the appropriate moment to have a break."
And there's times when you might have to remind counsel of certain things because they're focused on the job at hand.
That's right.
They're on their feet.
Correct.
And
then you pass the note to him.
You're passing notes, or you might have breaks, like you said.
And
That's why you were referring to the break before, I think.
Yep.
But anyway,
Look,
they have breaks for witnesses too, don't they?
They do, and if there is an issue at court where they need to talk to the barristers with the judge alone, they remove the jury and they'll have time out together.
All right. We've got to go to a break soon, and after the break, what are we doing, mate?
After the break, we've got the most fantastic and favourite part of the show. That's Viv's mailbag. Thank you.
Fantastic. Okay, viewers, stay tuned.